Anuja, thank you very much for taking time out. This does look like a judgment which is away from the norm. Now, given the complexity of the case and it's a POSCO case, we are, of course, not in position to divulge a lot of details. But what we do know so far is the court in this matter is suggesting that a sentencing is going to harm the victim more. So a sentencing as per the law will harm the victim more as opposed to giving her some sort of freedom and exercise to remain free and keep living with the perpetrator. In your assessment, what kind of a judgment is this, and what will be its long-term ramifications and impact on POSCO cases?
Yeah, hi, Shweta. So, according to me, this is more of a judgment on Article 142 of the Constitution rather than on POCSO. So, 142 gives Supreme Court powers to do anything that they want, which they feel is required to do complete justice. So, law is always, black and white, but there are gray areas where it has to be applied, and where if it is applied in black and white, there will be injustice done, and probably the victim will suffer more than she would benefit. So this is exactly one of such cases where there has been a very balanced approach of Article 142. The Supreme Court formed a very balanced committee where they examined the victim, they examined the facts of the case, and they came to a conclusion that today she wants to be married to that person. Both of them have been extremely traumatized by the whole legal process that has gone through, and justice in fact requires that the sentencing of the man be done away with. So I think this is more of a commentary on 142 rather than POCSO. Now the second question that you asked, that what sort of precedent will this set? So 142 does not set a precedent. It's an extraordinary power which is used very rarely by the Supreme Court, only when circumstances demand. So this is not a precedent on POCSO. Nothing in the law changes. In fact, the court has recommended that for situations like these, because acts like POSCO, they sometimes involve complex human relationships. This was one such case where there were a lot of complexities which the law is not prepared to handle, which the Supreme Court handled through 142. So, in fact, they have recommended that, probably consensual relationships is something that needs to be looked at, because 18 is a legal age over which you can enter into consent legally. But that doesn't mean that if you're below 18, you can't give consent. There may be cases where a woman has given consent even though she's below 18, and somehow POCSO has come into play. So, yeah, so I think it's a very good judgment. In fact, it's one of the finest uses of, in fact, one Article 142 that I have seen.
A lot of important clarifications you made there by the way of the judgment and how it is a commentary on Article 142 as opposed to POCSO. I have to ask you, as far as precedent is concerned, number of such cases prior that we have heard of where a victim ends up marrying the perpetrator or the accused, and in which case they find it as a loophole in the law and try and get away with it. Could such cases therefore be also considered on an individual level by the court, and could this also mean that more such cases may come to light where people cite this particular case and suggest that if some leeway was given here, perhaps they should also get a leeway? So what I'm trying to ask essentially is, does this set a bad precedent?
Right. So, I mean, that's a very good question, in fact, that whether this will be used in other cases where there has been actual commission of an offense, or, for example, where there has been rape. And a lot of times, perpetrators come forward with these ridiculous propositions that, okay, if I marry the girl, I will, make good the crime that I've committed. But no, it cannot be used as a precedent over there. Why? Because over here, it is the girl who came before the court, who came before the committee, and she stated that I'm extremely traumatized by what is happening. I don't want him to be in jail. We are very happy together as a family. So there is that difference. And there was an analysis done of the girl where it showed that they have
Sorry
actually been
to
suffering a lot.
cut you short, but in many cases, since the victim here, it's a POCSO case, so given that the victim here is under 18 years of age, and people under 18 years of age considered to be more gullible, people who can be easily brainwashed into thinking that this is what's right for them and they cannot make independent choices for themselves. There are past cases where a victim chooses to live with the offender because they believe that is the best outcome for them. How do you really then make the difference whether somebody has been brainwashed vis-a-vis somebody really coming out in open suggesting that this is what I wanted in my life?
Yeah, so the difference is that today she is above 18. So at that time she might have been underage, but when this judgment has come, And when she was examined by the committee, she is beyond 18. So, which shows that she has maturity, legal maturity to understand and know what she's talking about. So, there is that marked difference in this case, that today, when this is happening, both of them are above 18, both of them are adults, and they have chosen to take this step together. So that factor has also been taken into account by the court, that today she's not 14 and she is in a position to analyze what she has done and what she's speaking. So I think that marker needs to be there.
That marker needs to be there. That's an important one. At the same time, as I mentioned, since the offence was committed when she was under the age of 18, there is a possibility that perhaps at that point in time she did not know what was happening with her. But today she's matured, so she knows exactly as to what's happening with her. But I have to ask you, as far as interpretation of Article 142 is concerned, this is a precedent, you said, in that matter as opposed to POCSO case. Could you help us also understand if such cases happen time and again, if there is a precedent in this matter where the court has used a fine print of Article 142 to give a judgment which may not be quite in line with societal norms?
So typically in cases including sexual offences, Supreme Court particularly is very, very sensitive to victims' rights, and it is very, very sensitive to the fact that marriage between the offender and the victim is not a solution. In fact, it's considered to be very preposterous. It is only because of the exceptional circumstances of this case that Article 142 was exercised, and exercised in a very balanced manner after they took a view of psychologists and the committee that they formed. So it will not act as a precedence in that sense. And prior to this also, I don't think 142, as far as my knowledge goes, has been exercised in cases of rape in this manner, rape or POCSO sexual offences. So no, I think this is probably one of the first times where it has been used in a light where it has been used to help the victim. If you look at the other cases where this solution, so-called solution, is proposed, it usually comes from the accused, not from the victim so much, or from the judge to the accused, that marry her so that she can rectify her life, or because now she's damaged goods, nobody would want to marry her. So that perspective is missing in this particular case.